Oh, Father, tell me, do we get what we deserve? Oh, we get what we deserve.
Free for all.
And where down we go, oh, 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 where down we go, oh, 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 so where down we go, oh, oh, way down we go. Oh, you let your feet run wild. Time has come as we all go down. Yeah, but for the fall, ooh, my heart, do you dare to look them right in the eyes? Yes. Oh, 'cause say we run you down to the door. Yeah, someday we run you down till you fall. And they will run you down till you go. Yeah, till you can't grow no more. And where down we go, oh, 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 where down we go, oh, oh, oh. Say where down we go, oh, 'cause say we run you down till your car, oh, way down we go. Where down we go, oh, oh, oh. So where down we go, ooh, way down we go.
Enemy vulture on the field.
Oh, Father, tell me, do we get what we deserve? Oh, we get what we deserve. And where down we go, oh, 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 where down we go, oh, 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 so where down we go, oh, oh, way down we go. Whoa, you let your feet run wild. I'm as calm as we all go down. Yeah, but for the fall, ooh, my heart, do you dare to look them right in the eyes? Yeah. Oh, 'cause say we run you down till the door. Yeah, someday we run you down till you fall. And they will run you down till you go. Yeah, till you can't grow no more. So we're down. Oh, way down we go. Oh, Father, tell me we get what we deserve. Oh, we get what we deserve. And we're down we go. Oh, 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 we're down we go. Oh, 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 oh. So we're down we go. Oh, oh, way down we go. Oh, you let your feet run wild. Time has come as we all go down. Yeah, but for the fall, ooh, my heart, do you dare to look me right in the eye? Yeah. Oh, 'cause say we run you down, down to the door. Yeah, someday we run you down, down till you fall. And they will run you down, down till you go. Yeah, till you can't grow no more. And where down we go, oh, 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 where down we go, oh, oh, oh. Say where down we go, ooh. Oh, 'cause say we run you down, down to your car, oh, way down we go.
So we identify who the defendant is. And then what did that defendant do wrong? So we put in a complaint facts and we put what the defendant did or did not do. We don't put everything, but we put what is required under the law to give a good understanding of what we say the defendant did wrong. And then we put in some legal theories and put in what we are entitled to recover as compensation or other damages from the defendant. So, okay, what happens after the complaint's filed? So you're holding the complaint in your hands. What happens next? Well, the federal court is going to serve the lawsuit on the defendant. And that means to send a copy of the lawsuit to the defendant. Now, that could be the defendant directly. If it's a person, that's what it normally is. If it's a corporation, there's usually somebody called a registered agent, and that is the person or company that's designated to receive the papers. And normally that's done by certified court when we file cases here in Alabama federal court. Well, what happens after that defendant gets served? Well, now the clock starts ticking. Now there is a time limit involved. And that time limit is normally 21 days to respond after the defendant was served. Now, a lot of times they'll ask for additional time. It may be the lawyers get a copy of the lawsuit on day 20 or 21. So we'll give them additional time to file an answer. And then the judge says, all right, now you've got X number of days to file your answer. So let's talk about that. What is an answer? Well, it's the legal response to your complaint. So we may get a phone call, we may get an email, we may get a letter. It says, oh, this is outrageous and we didn't do anything wrong. That doesn't mean anything. What matters is, what does that defendant, through its lawyer, file in response? What does it file in court? Now, it can admit our allegations, the paragraphs, the things that we put into a lawsuit. Is very unlikely. We've had companies that have sued our client and then lost, and then we put in the lawsuit, you sued my client in small claims court, and they'll deny that. They'll say, well, we don't have enough information to know, which kind of makes you wonder, why wouldn't they know when they've sued somebody? Or maybe there's been a car wreck, and they may deny that the car wreck happened, okay? But the better companies and the ones that have the better lawyers will admit the things that should be admitted. Still, it's unlikely that happens. They almost always deny everything, though. Whether they should or shouldn't do that's another matter. But when they deny it, that means you have to prove it. Now, they'll also put in every possible thing that's called an affirmative defense. Okay? So what is that? That's where the defendant says, okay, all right, you caught me. I did it, but I'm not responsible because of blank. And that's the affirmative defense. It might be statute of limitations. It might be you've already settled with the defendant, or you filed bankruptcy and did not notify the court. It could be they say this is all your fault. Even though we're at fault too, you're at fault, and so you can't win. It's whatever they can put in there. Now, this does not surprise us. This is very typical. We're just bringing this up because we want you to know what this is when you see it, because you're going to see they'll just be page after page. It's amazing. A company that let's say it's a debt collector that's been calling you. They'll say, well, we deny that we called you, but then they'll spend 12 pages saying, but even if we did call you, we're not responsible. So it's another matter of whether they should be doing all these affirmative defenses. The judges are getting more strict about saying, wait a minute, only put legitimate stuff in there. But that's something we'll take care of in court. We just want you to know what it is when you see it. Now, what happens after an answer is filed? Well, we need to get a scheduling order. And the scheduling order is the process or the deadlines of what will happen, when things will happen, and when we're going to try the case, when certain deadlines are. So to do that, we first meet with the lawyers, and then we submit a report to the court giving a proposed scheduling order. So that's our next step, step 3. We got to get that scheduling order from the court. So after that answer, we meet with the lawyer. This is called the party planning meeting. And this is not something that you need to be there. We take care of that for you. We meet with other lawyers. We lay out deadlines. Normally we can agree on everything. But if we cannot, then we say, well, here's what we say and here's what they say. And we submit that to the judge, and then the judge has that. Now, what does the judge do with it? Well, some accept it completely. They don't make any change. Other judges will change it. Typically, though, the lawyers, at least the experienced lawyers on the other side, they know what the judges want. They know in terms of deadlines what typically each particular judge wants in a case. And so normally there are not a whole lot of modifications to that order or to that report that we've submitted. Now, we'll submit to you, we'll send to you the report and certainly the order that comes out. And usually we go ahead and attach kind of a summary of all the deadlines just to make it easy for you. And so as you go through your lawsuit, when you get things from us, you'll be able to refer back to this video and to the slides that you have in hard copy, And that'll help you keep your place as to where are you in the process. Okay, so what happens after that report is submitted? Well, the judge will send the scheduling order. As I mentioned, we'll send that to you. And then normally right after that report is submitted, even before the judge enters an order, both sides will send each other what's called discovery. We'll send it to them, they'll send it to us. So that takes us to step 4. This is the discovery process. And this is, in most cases, the longest period of time in the case is spent in the discovery process. So first of all, well, what is discovery? That's where we get to ask questions of each other and we get to demand documents. Okay? So the questions can be in writing, they can be spoken, and we'll talk about that. That's what's called a deposition. And we can say, well, hey, I want you to give me these records or these documents. And of course, the defendant can do that to you as well. So we'll take their deposition, they'll take your deposition, maybe other depositions. And so here's a critical thing. What do you need to do when you get this discovery? Well, first of all, it won't be sent directly to you. It'll come to us, and then we'll send it to you. Now, there may be questions that we see on there that you don't have to answer because they're improper questions. But unless we tell you that, go ahead and answer all the questions to the best of your ability and gather all the documents that possibly relate to these questions. If you're in doubt, go ahead and gather it together. Now, you may have given us all the documents. We tend to try to ask for everything that we think may be relevant in the case. But there may be questions asked that you realize, oh wait, I got another box of documents. If you're in any doubt, bring us all those documents. And sometimes we have clients say, well, why do I have to answer these questions? These questions seem silly, or I don't see how they're relevant or they're related. Well, just understand, this is part of the process of being in a lawsuit. And keep in mind, both sides think that they're right. Okay? So we think we're right, or we wouldn't have filed the lawsuit, and the defendant thinks that it didn't do anything wrong, or even if it did something wrong, it shouldn't have to pay you any money. Or even if it has to pay you money, it shouldn't pay as much money as you want. So both sides think that they're going to win, that they're right, and both sides have to play by the rules. And we always want to answer the questions, provide the documents, and what we find is typically the defendant is going to refuse to answer questions, refuse to produce documents. And a lot of times this is just part of their strategy. And I've talked with defense lawyers and they say, oh yeah, this is what we do, because we figure it just makes you work harder and maybe you won't hold our feet to the fire. And I think that's improper, but that's the approach that is typically taken. And when either side does not properly answer the questions, there can be some pretty serious consequences. So we always want to make sure that we answer properly, and then we'll point out to the judge that the other side is playing games, or they're being dishonest, or they're hiding documents. And so let them be the bad guys. We want to be the good guys here. So let's talk about those consequences, though. If we refuse to answer the discovery, well, judge can throw your case out. Judge can, if it's the defendant doing this, there can be really bad consequences. They may lose some of their defenses. They may lose the right to argue certain things in court. And whichever side is being difficult and not playing by the rules may have to pay the other side's attorney's fees. And so I'll say this, we have never had a client that just says, I refuse to answer questions. We've had some clients, that's why I have this slide, that say, why do I have to do this? But just understand that this is part of the process, and when you filed the lawsuit, you agreed to do this. And it's really not difficult, because all you're doing is telling the truth. And so we'll be there to help you. So the question is, well, how much time does it take? Well, it's going to take you a number of hours. But this is a critical part of your case. And so we want to get this part of your case right, because this is the foundation of the lawsuit. what your discovery responses will be. Now, we also obviously build on what the defendant provides, information, sworn testimony, but it's really critical. This is a part that you can control because you know the answers to these. We'll help you. We'll help you to look at documents. We'll help you to understand which documents to provide, but really spend some time and focus in on this because this is very important for you to do. And so we usually ask the question, well, can I meet with you? Well, of course, we're always going to meet with you. We're going to help you to understand what the question's asking. A lot of questions, there are improper parts to them, so we'll help you understand, well, you should answer this part, but not this other part. Or there may be legal objections, and we take care of that. So when you get these discovery requests, you just call us 205-879-2447. Ask for Melissa to set up a meeting with you and Stan. Sometimes he does that by phone. Often that's in person. There may be multiple meetings. And so once we get through this, what's called written discovery, and these are called interrogatories, requests for production documents, requests for admission, then we start looking at depositions, is how it typically goes. So depositions, that is step number 5 here. So what is a deposition? That's where the lawyers get to ask questions of the other party. So, for example, when we take a deposition, we get to ask the defendant or employees of the defendant questions under oath. Well, how long does that take? Well, normally about a day. And it's about 7 hours or so of actual testimony. And then the defendants get to take your deposition as well. They want to ask you questions under oath. Well, what do you need to do to get ready for when we take the deposition of the defendant? Well, we're going to get ready for that, and Stan normally takes those depositions. But here's how you can help us. We're going to ask you questions about what happened. And you may think, well, why do I need to answer that? Well, that helps us to prepare our questions. So the answers that you give us help to paint the picture of what happened. And then when we're talking to this representative or this employee of the defendant, we want to be able to ask questions to see, do they agree with your version of what happened? Do they disagree? Are they going to take absurd positions? And I'll just tell you this, a lot of times they do. You know, they take positions that I think, who in the world came up with this? You know, first of all, you need to tell the truth. But if you're not going to tell the truth, why say something so stupid and absurd? But I'm just amazed at and we're talking major corporations will do this. They will just flat out lie and lie in a dumb way. But hey, that's fine. They're under oath and there are consequences when they do that. And we'll talk about for you as well when you're given a deposition. So, all right, what happens after we take the deposition of the defendant? Well, we'll get back what's called a transcript, and that's just a written record of the deposition. Now, a lot of times we videotape the depositions because that tends to make the witnesses and the defense lawyers behave better because they know that it's being captured and they don't want the jury to see them being jerks and being difficult and taking absurd positions. But sometimes they still do that even when we video. But we'll send you either a transcript or the video just so you can see that. But before we even do that, normally your deposition will be taken first unless the defendant's just dragging its feet not doing anything. It'll normally want to take your deposition. So this is where you will be questioned under oath. Now Stan's going to get you ready for that. All right. We one time had a client say, well, am I going to be by myself in my deposition? Absolutely not. Stan will be there with you. He's going to make sure the questions are proper. If they're not proper, then he'll object to those questions. And look, this is all you have to do. Simply answer the questions truthfully. That's all you have to do. Now, Stan will prepare you for how to understand the questions, what to look out for. Sometimes lawyers will purposely ask very confusing questions, and so you'll be very well prepared. And it'll take some time. It may take a day, it may take 2 days to get you ready for deposition, but it's all time that's very well spent. Okay, so what happens after your deposition? Well, again, we typically get a copy of that transcript. We'll send that to you, and we normally ask you to look over that. If there's anything any mistake or you think it was taken down wrong, let us know, and we can talk about what to do next. Okay, so now, once we're done with all of that discovery, and remember that's the written discovery in step 4, and the depositions where questions are asked, either in person or it can be done by video or telephone. We always do it in person, usually with a video camera as well. But once all that is done, now we're at step 6. And sometimes this is called the dispositive motion stage. Well, what in the world does that mean? Well, that just means that both sides have the option. They don't have to, but they have the option to file a request. And in litigation, a request is called a motion. A motion is just where you're saying to the court, okay, Judge, here's something I want you to do. So you make a, quote, motion that happens. And there's something called a summary judgment. And that is where one side or both sides can say to the court, look, there's no need to go further with this. You can look at the facts and then look at the law. Look at the facts and then the law, and then whoever's making this motion says, look, there's no way a reasonable jury could rule for the other side. Well, if there's no way a reasonable jury could rule for the other side, then the judge should just summarily enter judgment now, rather than going through the time of a trial if we already know how this thing is going to end. So who can win a summary judgment, or who will win? Well, either side can win. It could be the side that's moving for the summary judgment, or it could be the side that's saying, no, this needs to go to trial. Both sides can move, and so one could win and the other could lose, or they both could lose the summary judgment issue. Here's the truth of the matter. Normally, the judge is going to say, there are facts that are in dispute, and the judge can't decide that. So let me give you an example. Take a simple situation of a car wreck case. There are two people in a lawsuit. I say I had the green light. The other side says he had the green light. Well, who had the green light? Well, the judge normally can't decide that. A jury has to decide. You have conflicting facts there. So let's take a credit reporting case. The credit bureau, Equifax, Experian, TransUnion, they'll come in and say, hey, there's no way a reasonable jury could find against us because we did everything right. Now our response is, well, no, you didn't. You have false credit reporting. And the credit bureau will go, yeah, I understand we have false credit reporting, but we were reasonable in what we did. Well, that's normally up to the jury. The jury will decide. When the credit bureau ignores all the information you send, when they refuse to read a judge's order and they still put false information on your credit report, or you send them a letter from the creditor saying you do not owe any money, and the credit bureau says, oh, we're going to ignore that and put down that you owe $5,000. Or a debt collector says, I never lied to you. And your testimony is, yes, you did. You lied to me. Well, a judge has to look at that and say, well, can I decide who's telling the truth? Normally the answer is no. That goes to the jury. And that's why that discovery process, those are the couple previous steps here. That's why it's so critical, because we're developing the evidence that we can use to show that summary judgment in favor of the defendant is not appropriate. And in the right circumstance, we can show that we should get summary judgment. So if summary judgment is granted against us, then this means that normally the case is over. Now, sometimes it can be a partial summary judgment, but we'll keep it simple. If you lose summary judgment, it means you did not go to trial. And so summary judgment is really the last step before trial, where either party can say, hey, judge, no reason to go to trial in this right now. Don't let a jury rule on it. Well, what if we win the summary judgment motion? Well, that means that the defendant's attempt to throw the case out has failed and we are headed to trial. Or maybe it was our motion for summary judgment that was granted. Whatever's left for the jury, then that's what we are looking at when we proceed to trial, which is step number 7, going to trial. So we get a trial date. Sometimes we get that when we get that scheduling order, if you remember back from one of the first few steps. Then the judge will sit down with us at what's called a pre-trial and say, okay, here's the actual week of trial that you're going to have. Now there's a lot to do once we get that trial date or once we know we're going to trial, and we have other information that we'll get to you at that point. But ultimately, when that trial date comes, then we go to federal court to try our case. Now, what does that mean to go to trial? Because you may have never been in a trial, and your only experience may be things you see on TV, which sometimes are accurate and oftentimes are inaccurate. But when we talk about going to trial, we mean everybody's going to be there at the courtroom. That's you, the defendant, the lawyers, the judge, and the jury. Now, both sides get to present evidence, and that's done through testimony, through witnesses, through documents. Both sides get to make arguments about what does that evidence mean and how does that evidence fit in with the law that the judge gives. Now, the judge, his or her role is to rule on the legal issues. And that also means, is this evidence proper? Is it improper? The procedural rules, the judge will control the court, make sure everything is functioning and operating smoothly. And then the jury will rule on the facts. So go back to a couple of examples.